Welcome to the series of Basics of Interpretation of Statutes. In this video, we'll talk about the difference between the new law and the amendment law. Now, a new law is enacted in the two circumstances. One, when there is no existing law on a particular subject matter. For example, Protection of Children from Sexual Offences Act 2012. Now, before this act, there was no law dealing with the sexual abuse of the children. So, a new law was enacted. Secondly, a new law was enacted where there is a previous existing law on a given subject matter, but that law has become outdated. In that case, the legislature enacts a new law. The example of it is Bharatiya Nyaya Sanhita 2023. As there was already a penal law existing on that subject matter, that was Indian Penal Code 1860. But it has become outdated over a period of time. Therefore, the legislature has abolished that law and enacted a new law, that is Bharatiya Nyaya Sanhita 2023. Now, whenever a new law is enacted, it lays down the whole new law on a particular subject matter. Now, in the second circumstance where there is an already existing law, in that case, the new law enacted by the legislature performs two functions. One is laying down a new law, and secondly, repealing the previous existing law. It means abolishing the previous existing law. Now, the second type of law which can be enacted by the legislature is the amendment law. Now, amendment means changes made in the existing law. It means the law is already existing, but certain changes are made in that law. Then that law is called amendment law. And the example of it is the Waqf Amendment Act 2025, as it has brought changes in the existing law, that is Waqf Act 1995. When the amendment and the new law is that whenever there is an amendment in the law, in that case the law which is making an amendment use the word amendment in its name. For example, Waqf bracket amendment and then Act 2025. So the word amendment is used in the name itself. But when a new law is enacted by repealing the previous one, in that case the word amendment is not used. For example, Companies Act 2013, the Consumer Protection Act 2019. All these laws are examples of the law where a new law was enacted by abolishing or repealing the previous law, and the word amendment is not used in the name of these laws. Now, whenever an amendment is made in a law, then certain kind of changes can be made. The first one is the introduction of a new provision. Now, we can add a new provision in the already existing law. Now, we know that the provisions are numbered as 1, 2, 3 consecutively. Now, the question arises how we can add a new provision. Now, we can do it by using the capital alphabet along with the number to add a new provision. For example, under the Constitution of India, there was no provision with regard to fundamental duties. But later on, an article, that is Article 51A, was added after Article 51 with regard to fundamental duties of the citizen. Now here, the number 51 is used because it is added after Article 51, and we use the word alphabet A, capital A, along with it to add a provision. So Article 51A was added. So if you see any provision with the capital alphabet, it shows that that provision is added by an amendment and it was not originally a part of the statute. Now, the second change which can be made by the amendment is abolition or omission of a complete provision. It means the whole section or article is deleted from the statute or law. The third change can be substitution. Now, substitution is where both action, addition as well as omission, is made together. It means the existing provision is deleted and a new provision at its place is added. In that case, we use the word substitution. Now, all these three actions, addition, omission as well as substitution, can also be made with regard to certain words used in the provision. It means the whole provision is not added, omitted or substituted. Rather, only certain words are added or omitted or substituted in a provision. Now, if you see laws, in that case, you will find that the legislature uses the term either omission or repeal whenever there is a deletion of a provision. It means these two words are used interchangeably. But the rule of the law says that if the legislature use two different terms, then they have different meanings. We cannot equate these two terms. So a question arises whether the word omission, repeal and substitution have different meaning or they are same. Because in omission a provision is deleted, in repeal a provision as well as the complete law can be deleted. And if we talk about substitution, though there is an addition of a provision, but at the same time the earlier provision is also deleted. So when the legislature is using three different terms, whether the legislature is intended to give different meaning to these terms, this question arises. Now we can find the answer by referring section 6 of the General Clauses Act. Now the section 6 of the General Clauses Act says that whenever any provision is repealed, its effect will be on the future cases and not on the pending or decided cases. It means if any case is pending, when the provision is repealed, in that case the pending case will be decided by the repealed provision or law. Now from this the inference is made out that in case of omission or substitution, the effect will not only be on the future cases but also on the pending cases. It means pending cases will not be governed by the omitted or substituted provisions after the deletion of the provision. Now this confusion or inference was corrected by the legislature by adding section 6A under the General Clauses Act, which says that the effect of the word repeal, omission and substitution is same, that the repealed, substituted or omitted provision will affect the future cases and not on the pending cases. So by addition of section 6A under the General Clauses Act, the effect of repeal, omission and substitution becomes same. Now this issue was also decided by the Supreme Court in 2015, where the court held that the word of omission, repeal and substitution is same, that these provision will affect only the future cases and not decided or pending cases. Now similar issue again cropped up before the Supreme Court in 2021. The matter was dealt with Consumer Protection Act 2019. Now Consumer Protection Act 2019 repealed the previous Consumer Protection Act 1986. Now one change brought by the 2019 Act was with regard to the jurisdiction of National Consumer Commission. Under 1986, the National Consumer Commission can deal with cases where the amount of the case is above 1 crore. But under 2019 Act, this pecuniary amount has been increased to 10 crore. It means under 2019 Act, the National Consumer Commission can deal with cases which are above 10 crore rupees. Now, when the new law was enacted, at that time one case was pending before the National Consumer Commission and the amount of the case was 2 crore. And when the matter came up for hearing before the National Consumer Commission, in that case the Commission refused to hear the matter on the ground that now the pecuniary limit of the National Consumer Commission is above 10 crore rupees, and whereas the amount of the case is up to 2 crore rupees. Therefore, the National Consumer Commission has no jurisdiction to hear the case. When the order of the National Consumer Commission was challenged before the Supreme Court, in that case the Supreme Court said that the pending cases will be governed by the repealed law and not by the new law. Therefore, National Consumer Commission is bound to hear the pending matters as per the provisions of 1986 Act and not by 2019 Act. I hope this video helps you to understand the difference between the new law and the amendment law. and what is the effect of repeal, omission and substitution. For more such videos, please subscribe to the channel and share it with your friends.